First Caribbean International Bank Barbados Limited and another against Interested Creditors.
Yes. What's that?
Good morning, my lords.
I'm sorry about that dreadful noise. I hope it won't happen again.
My computer's working.
You've got the main screen, haven't you? Good morning, my lords. May I proceed?
Yes, please. Yes.
Lords, it's the appellant's case in this appeal to Her Majesty's Privy Councillors are essentially, I will commence with grounds 1, 3, and 4 in this appeal. To show and establish that the legal rights which are asserted in the counter notice of appeal filed at the Court of Appeal on the 22nd of December 2016 were left at large. In the Court of Appeal's judgment delivered by Justice Bledman, whilst Justice Bledman quoted paragraphs 8 and 9 of the appellant's counter notice of appeal, not one word of consideration was given to Section 297 of the Companies Act, and in my respectful submission, the statutory indemnity therein given to a receiver against his personal liability to be indemnified out of the assets of the insolvent company in priority to the first respondents appointing creditor, the debenture and holder, which is the respondent bank, first respondent. The Court of Appeal gave absolutely no consideration to the appellant's legal representatives' use of sections 2971A and B and 3 of the Companies Act, which, again, in my respectful submission, was not only articulated at bar, but in which the appellants had filed copious submissions and written submissions on the critical importance of the said section 2971A and B to protect appellants' rights by subrogation to their post-receivership contracts to be indemnified out of the assets of Sunset Village in priority to the appointing creditors, which is the respondent bank in this case. As a result, my lords, I believe that no proper consideration was given to the expenses of the receivership and the claim of the appellants that the receiver's expenses in relation to the liabilities that he had incurred in the consent orders in settling their claims were overlooked. It is also part of the appellant's case and at bar and here today that because a receiver is entitled to his expenses, and his expenses amounts to a privilege debt, that the appellants do not have to prove themselves in the insolvency. And that goes back to the point in issue that the receiver is given an indemnity for contracts entered into by him, for compromises entered into by him, for settlements entered into by him, out of the assets of the company under which he is the receiver for. Parliament, in that regard, has made it, in my respectful submission, crystal clear that the receiver is therefore given that special privilege position, so much so that his expenses represent a charge on the assets of the company, and reflected in that charge are his expenses. That was essentially the point, and which, in my respectful submission, was overlooked. As indicated, my lords, no consideration in the sense of, was reflected in the judgment of the Court of Appeal in that regard. And that is in spite of the fact that the appellants had written submissions to that effect. My lords, it is also my respectful submission that the statutory indemnity given to a receiver under Article 297, 1A and B, qualified by Section 3 of the Companies Act, is not in contradiction or opposition to the code, the Civil Code of Saint Lucia. And the Code of Saint Lucia, the Civil Code, the Civilian Law of Saint Lucia, when examined at Article 1903, of the Civil Code, lists the privileged debts that take priority over a hypothec. And that is over priority, in my respectful submission, of the bank's hypothec. My lords, I want to rely heavily on the Privy Council case of National Insurance Corporation against Winmark, in which the Privy Council discussed quite succinctly, quite clearly, the import of a privileged debt. And in fact, the Privy Council in National Insurance Corporation had enumerated and cited the effect of Article 1903. And at the top of the rank of privileged debts lies law costs and expenses on the immovable. As alluded to earlier, it is my respectful submission that the receiver is a privileged creditor and that the charge on the assets of Sunset Village, under which he had taken control of, reflects his expenses, and also, my lords, in the National Insurance Corporation against Winmark.
Where do we find that?
I think it's page 1147.
In National Insurance Company, the
Not in mine.
lordships were very clear that at paragraph 4, paragraph 5.1, my lords, that certain individuals are preferred creditors and thus have legally protected privileges. These entitle the individual to payment in competition with others having similar rank in preference to secured creditors, such as the holders of hypothecs. And at paragraph 7, the prima facie, therefore, a privilege that takes priority to a hypothec. My lords, the Privy Council in this case was of the view, and I believe that the point is relevant here as well, that the error in which the Court of Appeal had fell into what I call the miss point, or the fatal error on the part of the Court of Appeal, is that it focused entirely on, I believe, Article 1967 of the Code, which clearly states that, that for a real right, for example, like that of a privilege, to take effect, has to be subject to registration. However, I believe that the Court of Appeal missed the qualifying point in that regard, and that certain privileges are exempt from the requirement of registration. And that exemption lies at Article 1969, which says that...
Where do we find that?
My lord, if I were to go to it, if I
It's
may be given a moment.
922, I think.
Did he say 922?
Article...
Yeah.
922.
Article 1969 exempts the expenses under a movable from the requirement of registration. And therefore, the Court of Appeal's emphasis in its judgment at paragraph 4, that real rights rank according to the date of their registration, and therefore FCIB's debenture ranks ahead of all other registered real rights, and therefore judicial hypothecs of all of the interested parties, and its debenture was duly registered mortgage charged against the property of Sunset Village, Inc. I believe, my lord, that that is where, in my respectful submission, the Court of Appeal went wrong, because it did not consider Article 1903, which lists a privilege like that of expenses at the top of the rank of rights, privilege rights, and it failed to consider Article 1969 of the Code of Civil Code of Saint Lucia, which exempted expenses from the regime of registration. And in the authority which I had made reference to, my lords, in the National Insurance Corporation against Winmark, at its paragraph 10, last sentence, where it says that Article 1969 provides that certain specific privileges, law costs, municipal and local taxes, salaries, and wages are exempt from the formality of registration. My Lord, as I said earlier on, when I read that, I had quickly gone to Article 1903 of the Civil Code, and whilst their lordships did not mention expenses therein, it is still there as a privileged debt. And when you look at Article 1969, you see that expenses are exempt from the requirements of registration. Excuse me, my lords, if I may. My lords, therefore, in regard to this Article 2011, as I had indicated, explains, again, quite succinctly, the rights, the effect of exemption. And it says privilege, that is a...
Where are you reading from?
The Winmark National Insurance Corporation. Paragraph 10.
Thank you.
At the last sentence, it says, the effect of exemption appears from Article 2011. And it goes over the page to say, privilege rights which are not subject to registration take precedence according to their respective rank, except the above cases, real rights rank according to the date of registration. And again, my lords, if you go to Article 1903 and 1969, you will see that because an expense does not have to be registered to take effect as a real right.
So where is this?
This is at Article 1969.
Do you have references for your citation?
Yes.
Because otherwise we can't find them.
Yes, thanks.
69 is at...
922.
yeah.
And 1903 is at page 909.
Yes.
Yes.
Thank you.
Thank you very much. So when examining as my lords put it in the National Winmark case, the order of priorities enumerated at Article 1903, top of the ranking of this privilege debt is law cost expenses. And not exempt from registration, that is, means that it still lies at the top of the ranking as a privileged debt. And as the National Insurance Company against Winmark makes very, very clear, my lords, that is that, if I may find it, yes, at paragraphs, again, for want of repeating myself, 5 and 6 and 1, paragraph 6.1, certain individuals are preferred creditors and thus have legally protected privileges. These entitles the individual to payment in competition with others having similar rank, in preference to secured creditors, such as the holders of hypothec. And at paragraph 7, prima facie, therefore, the privileged debt takes priority to the hypothec. And then their lordships go on to point out the, the position in France by decree of 1955, saying that privileges over immovable property were converted into hypothecs legals, and which require registration to retain their priority. But this is the position that the privilege of the receiver being a privileged creditor in that regard, that the privileged debt of his expenses takes priority to the hypothec of the of the bank in this case.
Are you going to come back to Article 1903?
Yes.
On page 922, or 909?
Sorry, hello?
Are you coming back to Article 1903? Because if you're leaving it, I've got a question for you about it.
Yes, yes, my lord.
You'd like me to ask the question now, or are you going to come back?
Yes, my lord.
I think you're saying that your claim can be got within 1903.1, being one of the specific items mentioned in Article 1969 as giving a exemption from registration.
Yes.
I've got two questions, really. One is, what law cost or expense of the receivers was incurred by reason of the consent orders? And the second question is, why should we take the view that the receivers were acting for the common interest of the creditors when they'd been appointed by the bank?
Yes, my lord. Right. My lord, I think if I may just a second. If I recall your first question, my lord, that is that my lord, if you could repeat the question.
Yes, the first question is, what law costs or expenses were incurred by the receivers by virtue of their consent to the consent orders on which you rely?
Yes, the point that we are making is that the consent orders in themselves were a power in which the receiver was possessed with, not only under the instrument under which he was appointed, that is the hypothecary obligation, which lied at clause 7 of the hypothec under which he was appointed. The receiver was also vested with the power to enter into settlements and compromises and contracts to defend claims and even make claims under that hypothec, the obligation. It was also noted, actually, by the receiver in his first receiver's report that on pre-appointment that he had to consider the legislation in regard to his authority in the insolvency of Sunset Village Inc. And Article 284 of the Companies Act gives him the statutory power to compromise and make settlements. So
on behalf of the company?
On behalf of the company, on behalf of the receiver, on the report of, in his role as a receiver manager, or even that of a receiver, he is vested with the legal authority to make compromises and settlements on behalf of the company, that is, after having taken the assets of the company under his control.
And where do we find section 284?
Yes. Sorry?
It's in the bundle somewhere, presumably.
Yes.
Where?
Oh, well. Section 284,
Yes. Companies Act.
Companies
Was
Act.
it? The extract I've got here only starts at 287, at page 959 of the bundle. I'm just looking at the index at the moment.
If I may, what was this?
Yes, it doesn't have 284. I think it was 284 you told me that was the section that gave the receiver power to compromise.
Yes, section 284.
Do we have that anywhere in the bundle?
Yes, I have the Companies Act, my lord, if I may.
We seem to have sections 287
Yes.
to 466.
I don't want to take you out of your course, Mr. Foster. Let's assume for the moment that that is what section 284 provides. My question remains, why did the receiver's consent to the consent order involve him in incurring a law cost or expense within the meaning of Article 1903?
Yes. The Article 1903 reflects the debts of a privileged creditor. My respectful submission is that the receiver becomes a privileged creditor when he, on behalf of his appointee, the bank, is given not just the authority under the hypothec to enter into contracts, compromise, and make settlements. He's given that authority under his deed of appointment, and he's also given the authority by statute, which is section 2874, to compromise, and that section 297 is instrumental here because it gives a receiver an indemnity out of the assets for liabilities incurred.
I have no difficulty with the concept that the receiver may have an indemnity for his liabilities. My difficulty is understanding why the receiver incurred any liability at all under the consent orders, if, as I think you have to say, the consent orders were a proper exercise of his authority.
Yeah. We are saying that the consent orders were the product of negotiations between the receiver and the appellants in this case. And it has the power of a contract, it has the power of compromise, it has the power of settlement, which at the heart of it carries with it an agreement. In this case, the receiver could have done a number of things when faced with the claims of the creditors, the appellants in this case. He could have decided that he was going to reject the claims of the appellants, or that there was no substance in them. Instead, he committed himself, we say, and that's in the statement of facts and issues, and also in the written submissions into negotiations in regard to the appellant's claims, and that created a liability for which he's indemnified out of the assets.
But all he did was agree the amount of an existing liability. He didn't undertake some new liability which didn't previously exist on behalf of the company, or let alone himself.
We beg to differ, my lord, because the statement of facts and issues which were not objected to by by either the respondents at any time at all in these proceedings made it very clear from 2015 all the way to the 26th of January of this year that these consent orders were the subject of intense negotiation.
Yes.
There may have been, but the background surely is that there were already default judgments in unquantified amounts, and that the consent orders simply related to the quantification of the amounts that were due.
Yes, and that, as we've respectfully submitted, amounts to a contract which he being part of, not necessarily just rubber stamping, so to speak, the debts, but in agreeing to make that commitment, to make that payment to the appellants, is a contract or an agreement or compromise which is provided for.
Was he agreeing to make a payment to the appellants?
Yes, we are saying that he agreed to, with the appellants, to make the payments as...
Where do you get that from? Because all the orders shows is that the sum was quantified. That's quantifying an existing debt. It's not incurring a new debt which didn't previously exist.
Mr. Foster, you have no doubt in your excellent career as a lawyer have negotiated numerous settlements of liabilities on behalf of your clients with full authority and after the most detailed negotiations. But do you suggest that they involve you in a personal liability to pay the sum identified in the settlement agreement? And if not, what's different about the receiver's negotiation in this case?
Yes. The receiver, in this case, has the assets under his control. He's taken charge of them. In comes in the appellants with their claims. There is negotiations, and it's registered by way of consent. The receiver agrees, therefore, in that consent to pay the appellants the award that is reflected in those consent orders. And that, in effect, amounts to the agreement between them, the haggling, so to speak, the discussion that a particular aspect of damages is not provided for. There's no evidence for that, and decide that their dealings with the receiver would be respected as a payment in damages to them that they are entitled to. As I read it, my lords, this is not just simply a mere rubber stamping of what was decided in the default judgments, because the claimants had the option before the court, that is, before the master, to have not entered into negotiations with the receiver, but to have put forward their claims quite vigorously before the court. The receiver also had the option to defend the position of his assets before the master and assert that he's not committed to some of the expenses or not committed to some of the liabilities that were claimed by the appellants in this regard. And I think that therein lies a succinct and critical difference, that this was not simply a rubber stamping of the claims. There were indeed the real possibility under the CPR at the assessment hearing of the damages for the appellants to have presented their case before the master.
So if the cases had not settled and they'd gone on and been disputed, and the master had made an order quantifying, either agreeing with your client or,
yes,
or with the receiver, would that then be in a different position from your
yes,
from the appellant? So that would not then be an expense which was a privileged debt.
yes, yes. That is the point, because you see, my lords, the position here is that if you look at and study the receiver's reports, we see that as a receiver manager, he had vast powers and had power to continue running the company.
But he didn't come along in the negotiation and say, in order to keep the company going, I promise to pay the amount due to you. All he said is, you've got a default judgment, and I agree that the amount for which judgment should be entered is X.
No, no.
Well, that's what the consent order seems to me to say.
Yeah, yes.
Have a better look at it.
On the face of it, my lord, if you look at the consent orders in particular, we will, for example, and also if you look at the history of the case in this matter, which was never contested or disagreed to by either the first or second respondent, that the consent order, the product of the consensus, were the two issues here. There were the product of intense negotiations. There was certainly the haggling of what amount the appellants were entitled to. It wasn't just simply rubber stamp. That makes it.
You don't have to repeat that, Mr. Foster. Let's treat that as a given.
Yes.
But if one look, the consent order is at page 161 or 160 to 161. It's a consent order between your clients and the company, signed off by counsel for the company, Mr. McNamara, and on the face of it imposes a quantified legal liability for damages and costs and a stage payment arrangement on the company.
No, my lords.
I'm just looking at it.
Yes. And behind the consent orders, in fact, within the consent orders, if you were to look at the consent order of Mr. William Rose, for example.
I was looking at the one for cells and cells.
Yes.
It's page 171.
There was an oral hearing. There was an affidavit in support. And after hearing counsel for both parties, and even before that, my lords, the statement of facts and issues shows that there were adjournments made which were not contested.
Well, there was a mediation as well, so the order says.
Yeah, indeed, my lord. And in one of the, not wanting to give evidence from the bar table, but that in itself shows the extent of commitment by the appellants to obtain to recoup some of their losses and the result for filing their claims. And the receiver representative, Mr. Beausejour McNamara, wasn't prepared to just simply accept those claims or rubber stamp those claims. So there were oral applications, there were affidavits in support, there were adjournments, there were negotiations, and if the result had, I dare say, had come out the way some of the appellants would have liked it to have been, the award would have been much higher in their favor. So the receiver did benefit, we would say, to the tune of hundreds of thousands of dollars by entering into this consent order. So the subtle issue here is that there certainly wasn't a rubber stamping of the claims that were cited in the default judgments, and also at the assessment for hearing stage, the appellants had the option before the master to argue with full force and vigorously their claims with their counsel to make a decision relevant to their expectation for their investments made. Instead, the receiver decided not to rubber stamp those claims at full force, full whack, but to enter into negotiations. So there was a giving and taking.
Well, as I said, Mr. Foster, we're prepared to assume, for the purposes of the argument, that these consent orders were the result of heavy negotiation, active participation by the receiver, and that they secured for the company's benefit a lower damages liability than the claimants might have got, yes, if they'd simply got a default order in their favour.
Yes, yes.
But where does that... Let's assume that. You don't have to say that again.
Yes.
We're taking that as read, right, but the question remains, why does that mean that the receiver incurred a liability for which he's entitled to be indemnified? It sounds like he was acting perfectly properly in accordance with his duties.
But, my lord, again, my respectful submission is that the receiver was not obligated. He had the entire power to...
It does rather put the appointing creditor in a difficult position. I'm just thinking of the policy implications of what you're saying, because they might want to reduce the legal costs that are incurred in the receivership by instructing the receiver to settle and compromise on reasonable terms.
Yes, yeah.
But if the result of that is that the consent order then takes priority over their registered debt, that's a big disadvantage to them. Doesn't your argument have an unfortunate policy result, which is that the bank will say to the receiver, never compromise, never enter into a reasonable agreement, fight everything to the last dollar, because even if we have a judgment for more, it won't take priority over our charge.
Yeah.
And so that's actually better for us.
Yes. If I may, my lady, my lords. Therein lies the issue under our law and under the Companies Act, Saint Lucia. Even under within the hypothec itself, it gave, and in fact, Justice Bledman made a similar point in her judgment. Why would the bank, for instance, leave itself at large? But the reality is that all the receiver had to do was just allow the judgments to prove themselves in the claim without entering. The fact that he got involved and negotiated it, had he defended it, had he defended the claims, then I would suggest respectfully, then that is a route he had an option to take, and there could be no criticism for that. And in addition to that, if he did nothing at all, it would have simply meant that these would have been claims that would have had to have been provable within the insolvency or within the liquidation. But the fact that he got involved in the matter and negotiated the claims from a higher to a lower award, or vice versa, from a lower to a higher award in others, allows the consent, the status of a contract. And the legal authorities show that, for example, Mr. McNamara had indicated the issue of Gorman, in which I think their lordships are aware of, to the extent that the consent order can simply mean, no doubt, a rubber stamping, an agreement, so to speak. But we're saying that this is different, that those consent orders...
Well, I think we've got that, Mr. Foster. I'm conscious we don't want to use up too much of your valuable time in asking you questions. So if you want to move on with your argument, by all means, please do.
So I believe the subtle, my Lord, the subtle difference here is that it was also beneficial to the receiver, where in the receiver's reports, the receiver from the start-go had contemplated moving the companies into liquidation and therefore did not want to be caught up in a feud of haggling over the debts of the claimants. The receiver in the first receiver's report is very clear that there were already, when the judgments were entered, that the reason for trying to move the company into liquidation quickly was to prevent and to stay other claims. But the receiver's report itself therefore recognized, I'm saying inherent in that report is the recognition that the judgments were that which should be honored out of his assets, for which he has an indemnity. There was nothing in the receiver, any of the four receivers' reports, or any of the liquidation reports that indicated any objection to these consent orders having the status of judgments which he wanted to abide with, except only recently, on the 26th of January, submissions by Mr. McNamara. In fact, it was those expenses that he had legitimately incurred that, I would say, shook the ground to the extent that, again in the receiver's report, that he said, let's move the company quickly into liquidation so that we can stay the claims of other creditors. There was nothing about rejecting the claims of the judgments or considering that he was not responsible or that he was not going to be liable for those. And they also, my lords, if I may make this critical point, unlike the UK Insolvency Act and the Insolvency Act and the insolvency rules, which are very, which take into consideration the funding of an insolvency practitioner or of a receiver manager, even with the court's discretion, it has been referred to as that of a nightmare. Our law is very much simplified in that regard. And I believe that if we look at the fact that the receiver, having assets under his charge and under his control, had the power to defend and say, no, I'm not accepting these awards, it would have automatically have gone into the insolvency, and the claim appellants would have been forced to prove their debts within the insolvency process. But having made a steal, so to speak, and compromised his debts, in fact, it woke up the receiver to the reality, now that I've committed myself to this expense, let's move the company quickly into liquidation to stay other claims. And that is in the receiver's report. And that sort of issue is what binds the contracts, makes it a contract. As I said, the argument of that was accepted by Justice Wilkinson. Those were the product of written submissions put before Justice Wilkinson at first instance. She had the benefit of the written submissions of the interested creditors. And decided in her judgment, which I think is at page electronic 148 of the bundle, where she makes it specifically clear that after the remuneration of the receiver's fees and after the payment of preferential debts, the expenses of the receivership must be paid. And this was having before her the benefit of copious submissions on the point of the relationship between the receiver and the appellants, and driving it home, so to speak, the negotiations, and they're all there in the record, my lord, in the written submissions, which were not opposed to by the first or second respondent. And in fact, when the matter moved upstairs to the Court of Appeal, there was no objection put in by the receiver or by the first respondent bank that their consent orders, that the appellants were in fact entitled to that award. Nothing of that was cited in any of the notices of appeal at all, and there was absolutely no objection. The only objection which was made, an argument by the appellants, was simply that the awards of the appellants were to be respected, except that they ranked after. Put it in a nutshell, except that they ranked after that of the bank. And, my lord, the reason why we say the court fell into error, because the Court of Appeal also took the stance that this was a rubber stamping. Justice Wilkinson did not take this as simply a rubber stamping of the position, and then provided. And in her judgment, my lord, if you look at the oral judgment, which is starts at 140 of the electronic bundle, she repeats the consent orders verbatim. She calls out each of the consent orders verbatim. She then has before her the written submissions of the interested creditors and parties, and then decides, makes a decision that because the appellant submissions in 2015 before her and at her oral judgment in 2018 did constitute the expenses of the receivership, to which the receiver having an indemnity out of the assets would signify that it's a privileged debt to rank according to Article 1903, doesn't require that of registration, my Lord. And so, my Lord, the simplicity of our legislation, which, because if we read the common law authorities in Beausejour and another, and Beausejour and Talbot and Khan and another, and look at the insolvency rules, we see that the aspects of the expenses having to be beneficial for the whole insolvency process. In this regard, we are saying yes, it was also beneficial because it reduced the debt. And I believe that in that regard, we give the judge at first instance looked at that authority. We say that the law, the statutory powers, also give the receiver the authority under Section 2874 to make compromises and settlements. And it is these compromises in our law and these settlements in under our Act that is to be indemnified out of the assets and not to be proved. And so, as I stated, my lords, the receiver had the option to stand back and say that, I'm sorry, you'll have to prove your claim in the insolvency. And this, on the facts of the case, which were not opposed to by the first or second respondent, he did not do. He decided, my lords, to engage the receivers in that regard. So, my lord, we are saying, therefore...
Foster, can I just ask the questions that are bothering me about your analysis? Clearly you're saying these are expenses that class as preferential purposes of the code.
Yes.
And the question we're trying to answer is, are they the sort of expenses that fall within that? So one starting point, I think, would normally be that a liquidator, receiver, incurs certain expenses, fees and the like, and that's what you would normally be thinking of. But you're asking us, I think, in a sense, to extend what we would understand by the meaning of expenses. And the problems I have with that are, first of all, are these personal to the receiver, or are they not incurred on behalf of the company? In what sense are these the personal expenses of the receiver? That's the first question. And the second is that it isn't the receiver who's seeking priority, it's the creditors to whom the receiver is supposedly paying off the money or incurred the liability to. So I've got those two problems. I mean, it's not a personal liability of the receiver in the way that a normal remuneration fee would be, and it's not the receiver who you have to show has priority. You're talking about the creditors.
The right above subrogation, as articulated and understood, that the expenses of the receiver is for the benefit by the right of subrogation to that of the appellants. Therefore, the privileged debt is really a charge. The receiver's indemnity is a charge on the asset. That charge is like a hypothec, a privilege like a hypothec is a charge over someone else's property.
So that's how the fees normally work.
Yes.
Exactly.
Yes.
You've got a subrogation right in relation to your fees.
Your argument is that, if your argument's correct, you could have sued the receiver personally, and he would have been liable to pay the judgments. That's the effect of your argument, isn't it? And then he could have claimed an indemnity as expenses.
If I understand what you're saying, my Lord, the fact that the receiver entered into, we say, this contract or liability, because unlike Mr. McNamara's consideration of it being a Corpsman type contract, it was one that is one that binds him, and he having the assets under his control. Whilst he is acting as the agent for the company, his primary duties, his primary fiduciary duty is that to his appointing creditor. So that is recognized that, and in the hypothec, it's also recognized in the deed of appointment, and it's also recognized under the Companies Act. That makes it clear that any liability and compromise of the receiver is to be indemnified out of the assets and not provable in the insolvency. And that is the critical, subtle difference between the Insolvency Act and the insolvency rules in the UK, where the categories of expenses for petrol are all qualified to some extent, and very different to that of maybe a contract entered into by a receiver. We are saying, from under the interpretation of our Companies Act, that the liabilities of a receiver for settlements and compromise are an expense provided for as a privileged debt to the receiver, doesn't require registration, and through subrogation, the benefit of that is to the appellants. And he had, I think it's important, my lords, to know that the receiver had vast powers. He wasn't just a receiver manager. He wasn't just a receiver. He was a receiver manager under the Act, which gave him the authority to act as to manage the asset fully. And if he therefore decides in the management of the asset to settle these creditors and then run to liquidate the company rather than get other claims, because the receiver had the knowledge that other claims were there, he could have taken the same approach. If we were to look at the receiver's reports, we will see that he was fully cognizant of what he was doing. He was happy with his debt. There's absolutely no criticism that in his role as manager, he will settle these debts. Then, thereafter, he decided, I'm doing this no more. So I shall rush the company into liquidation so that I could stop these claims. And had it been raised then, at first instance or at the Court of Appeal, that this was not the position, my respectful submission, it would have been reflected in the record. That position would have been reflected in the record. And I believe that is the critical difference, that if we look at his rights under Section 2290 of the Companies Act.
Sorry, which provision are you referring to?
If we examine
Is it page 962?
So Article 2019, which is at Electronic Bundle 962, my lord, thank you, says a receiver of a company may, if he or she is also appointed manager, carry on the business of the company to protect the security interests of those on behalf of whom or she is appointed. And yet he decided, which he had reviewed, yet he decided that entering into these awards would protect the security interest of his manager. And if you look again at the receiver's reports, don't have the reference close to hand, this was at a time as well when the asset was valued somewhere in the region of $23 million US. $23 million US. So there was no problem with the receiver to settle those debts. And there's nothing, absolutely nothing in the receiver's reports, the four receivers' reports, the four liquidators' reports that show that he was unhappy with that. In fact, the only issue I noted in the fourth receiver's report was that the legal counsel for the receiver had advised his receiver manager that the rights of the appellants and that of the bank were that on the basis of pari passu, which I think is obviously withdrawn. But that's in the report. That's in the report of the receiver. So, my lord, if we also, my lord, just before I leave this point, it says at 289, a receiver of the property of a company may, subject to the rights of secured creditors, receive the income from the property, pay the liabilities connected with the property, and realize the security interest to those on behalf of whom he or she is appointed, but except to the extent permitted by the court, he or she may not carry out the business of the company. So this is where it doesn't apply here, except that this is where a receiver is only appointed to sell the asset. So if we look at these sections closely, my lord, and we also look at the receiver's reports and the liquidation report, we see, and we also examine the fact that how, as Justice Wilkins saw it at first instance, that they were negotiated. It wasn't simply a rubber stamping. And so I'll move on.
Mr. Foster, you didn't answer, I don't blame you for not answering because we had a lot of questions and answers on my first question, but you didn't answer my second question, which is why should we assume that in compromising some creditors' claims against the company, the receiver was acting for the benefit of all the company's creditors rather than for the bank by whom the receiver had been appointed? Speaking for myself, I can well understand that a receiver might think it in the interests of the bank to postpone liquidation by settling with pressing creditors because the bank wanted to keep its manager in the saddle for a bit longer before the company went into liquidation. But I don't understand why we should assume that was being done within the meaning of Article 19031 for the benefit of all the creditors.
Under Article 1903, my lord, the we would need to look into the mind of the receiver manager. All we can do, my lords, is to look to his reports and to the liquidation reports, and not to second judge him, and to know that as a receiver manager, he decided that it was at that time in the common interest of the creditors to make the compromises as he did.
Is there anything in the reports that would lead us to, or could lead us to, a conclusion that he was acting for the benefit of all the creditors rather than the bank?
Yes, my lord, because there was no objection at all to the judgments, no objection at all to the judgments at that time, and I think timing is everything in this regard. On the 13th of February, when he went into the judgments, he was acting in the common interest of all of the creditors as per presented to him at that time. That was critical. I believe that it was the other claims that kept coming up, maybe the success of the appellant's claims at the time, and maybe the issue of the value of the property diminishing itself, and also the issue of not being able to get a foreign investor, because there are receivers' reports indicating that the asset was worth 23 million US dollars. There was another one at 21 million US. Then all of a sudden, the asset is sold at 6.5 million EC dollars. So at that time, when he entered into negotiations with the interested creditors, it certainly was in the common interest of all the creditors. I'm saying it is strongly inferred that it was in the common interest of all of the creditors at that time. It is only as time quickly elapsed as he then began to quickly to secure the interest of the bank. And that is where Article 1903, 1901, 1903, I believe, takes effect, my lords, in this regard.
Thank you.
So, my lords, on this grounds, on these grounds, I would only ask your lordships to carefully examine the extent, because as I had indicated in my supplementary case, to be put on alert for the first time by Mr. McNamara, Mr. Boto McNamara, on the 26th of January, which is less than 2 weeks before this hearing, that he had changed his very neutral position in all of this is inequitable, we would say, my lords, in particular, given his non-objection. I used language in my supplementary case to say that there was not a whisper, not a murmur of objection to the awards. And we just have to look at the statement of facts and issues. We have to look at the written submissions of the interested creditors that were filed on the 15th of May, 2015, which is at pages 326 of the electronic bundle. I ask your lordships to particularly examine paragraphs 7, paragraphs 8, paragraphs 9, paragraphs 10 and 11, and in fact, we will see that at paragraphs 11, 3 to 7 of the electronic bundle, the stress that was placed on the negotiations between the receiver manager and the appellants to come up with this award. These submissions go all the way. It's not something that we are now saying, all the way back to 2015, to show that there were intense negotiations which required adjournments. And so it wasn't simply a question of a rubber stamping, and that oral representations were made in courts, affidavits were there, of which not all of the affidavit evidence of the appellants were agreed to, and so hence binds the contract. And so, my lords, I'd also ask respectfully that to view those submissions vis-a-vis against the no objections by the first respondent or by the second respondent at any stage of the proceedings or the history of these proceedings, my lord. And that the only issue that the respondents had until the 24th, until the 26th of January, was the issue of registration. Real rights are only effective if they are registered. There is nothing in the Court of Appeals judgment that looked at a privileged debt having a higher ranking than that of a hypothec. The whole emphasis in the court below, except in Justice Wilkinson's court, was that the hypothec automatically registered first in time takes priority. And that takes me to one other issue on these grounds, my lord. And that is that if we understand the 297 and the academic writing on what constitutes a charge on out of the assets of the company, this is just a submission of mine, and I ask for your consideration on this, my lords, that we say, as I said previously, that charge on is reflected as a privilege debt, the expenses, because certainly the receiver could not pay for this, as we say in the Caribbean, with buckets of sand and water. It came out, it was a charge on the asset. It was a charge on the asset, and that reflects the expense. Now, that charge on, the concept of it being a charge on the asset, we look at Article 1933 of the Civil Code of Saint Lucia. And it, as I understand it to be, my lords, and I get your assistance with this, as I got assistance with their lordships in the National Insurance Corporation against Winmark case, as I understand Article 1933, which is given no consideration, where the bank, for example, has hypothecated the property of Sunset Village to itself, but tacitly, by its appointment of its receiver under the very hypothec, tacitly, not necessarily, we say expressly, but tacitly, and this is the word, my lord, that I ask for your interpretation on, creates a charge on an asset which was hypothecated to itself previously, that inverts the order of preference. The bank cedes its preference to that of its receiver, who has charged the asset in that way with his expense. And again, that takes it all outside the insolvency process. And I just ask, my lords, that you consider, and my lady, that you consider Article 1933 by virtue of the fact that the receiver was appointed under the hypothec of the bank, under any instrument, that is, and that whilst they had a previous hypothec to Sunset Village, if you look at Article 297, 1A and B, which considered it as a charge out of the assets, it means that that asset was charged with his permission, was charged because he represents the bank and his fiduciary responsibilities are mainly to the bank. He is charging the asset and therefore inverts the order of preference. That is under Section 6 on the order of hypothecs, my lords. So that is our position. My lord, if I may move on quickly. Then.
Just before you do, Mr. Foster, you directed the board to look at the receiver's reports as evidence that he was acting from the common interest of the creditors.
Yes.
Appendixed to his third report is detailed written advice as to his legal obligations, and in particular at page 380 of the bundle, I think. That's where the advice starts, and at page 381, under the heading Legal Obligations of the Receiver, it's recorded that so long as the receiver bona fide believes that the exercise of his powers is in the legitimate interest of his appointor, which here means the bank, his exercise is not constrained by reason of the fact that the exercise will occasion damage or loss to the debtor. If the appointor's interests as the receiver sees them conflict with the interests of the debtor, the receiver can give preference to the appointor's own interests, and the only duty owed to the debtor in such circumstances is to act in good faith. I'm not suggesting that advice comes as any surprise to someone who understands English insolvency law. It may be that that was regarded as applicable in Saint Lucia, but it doesn't look from that as if the receiver was being advised by his lawyers to act in the general interests of the creditors rather than in the interests of his appointor.
My Lord, if as I say, we go back to the issue of the I think it's the fourth receiver's report.
The fourth one. I think I ran out of steam after the third one. Is the fourth one in the bundle?
Yes.
Thank you. Oh, I see. It's got in. Yes, I've got it. Fourth receivers before the liquidators. Yes, thank you.
Where is it?
Page 388.
When we see, my Lord, at the, under the activity updates, under the fourth receiver's report, where it gives a history of his time with the company. And as I read
it... Which page are you on?
I have a hard copy bundle here, Lord. Let me see if I can get it.
I can find it if you give me the page of the report itself. I can see the pari passu advice to which you referred us a little while ago at page 392, paragraph 2.3.
Yes, my lord.
Is that what you were looking for?
Yes.
Thank you.
Yes, yes, my lord. That's what I was looking for, my lord. And so the idea of, at that time at least, of the receiver acting for the common interest of all the creditors, I believe, is clearly made out there, my lords. So, my lords, if I...
But why does the promotion of certain pressing creditors' interests to rank pari passu with the bank amount to acting in the common interest of all the creditors?
My lord, if I didn't quite understand.
My question is, bearing in mind that your case depends upon showing that in making these consent orders, the receiver was acting in the common interest of all the creditors, why does promoting certain pressing creditors' claims to rank, so your client was advised, so the receiver was advised pari passu with the bank, amount to acting in the common interest of all the creditors?
Yeah. The issue there, my lord, if I understand your comment, and if I may, that the position of the appellants, again, against the backdrop of a $23 million estate, and nothing in the report suggesting that he was doing anything else but acted in the common interests of the creditors, I believe is there, if we were to look at the timing of all of this. There's also the other issue that under our civilian law and our Companies Act, unlike, as I said, in referencing the UK insolvency rules and Insolvency Act, which really does go into the specifications of expenses and justification of expenses. We don't have that kind of complexity. It simply says that any liability, and this gives, therefore, puts the receiver on alert that he should not create any liabilities if he doesn't want to compromise his appointing creditor. Because the law is very simple in that regard and makes it crystal clear that his liabilities are not paid for in buckets of sand or water. They're going to come out of the assets under which he is appointed. And he is aware of that. Because if you look at his pre-appointment instructions, he reviewed, he says in the first receiver's report that pre-appointment, he had consulted Mr. Beausejour McNamara, and that he had reviewed Articles 288 to 300 of the Companies Act, which puts him on alert that at 2874, he has the power, you're given the power to compromise and settle debts, but if you do so, it's going to be indemnified out of the assets under which you're appointed. That will be a charge on the estate. And that's where the expenses, the charge reflects the expenses of privileged debt, I respectfully submit. And I also say that it gives, by doing that, having not just the power of a receiver, but a receiver manager, where he had the power as well to charge the bank's assets in the way he did through his indemnity, it gives an inversion, cedes the bank's preference in favor of that of the appellants, in this case, or anyone else, where it becomes a charge, if it becomes an actual charge on the assets or to the assets under which he's appointed, and that is the critical point I was trying to make, to view this in the context of the time that it was done as well, my lords, because the confusion here could very well be that you look at the receiver's reports, look at, in fact, how the property was valued, and then all of a sudden it becomes valued at $6.5 million EC dollars. That is not the fault of the appellants. It's not the fault of the appellants that they're to suffer for that, because in my respectful submission, it was not simply a rubber stamping. It was a valid contract, a valid liability to be taken out of the assets, my lord.
Well, Mr. Foster, we've got to 12 o'clock. So that was the time allotted.
Yes.
Is there anything you want to add by way of conclusion in the next couple of minutes?
Yes, my lord. I would also like just to end by saying that if my lords could look at the issue of the to examine the issue of estoppel in this matter, that it is having given under the law of Saint Lucia, under its own hypothec, that is under Clause 7 and Clause 8 of its own hypothecary obligation, given the receiver manager such vast powers, and under the deed of appointment as well of the receiver manager, that settlements, consent orders, if, as Mr. McNamara now determines, only now, and I suggest that that only occurred because of only now determined, only now determined, my lords, the issue of the consent orders. That if he, in other words, if he was, and yet it's all written in both the submissions which Justice Wilkinson approved of in her decision, in the Court of Appeal, those aspects of the consent orders having valid contracts were not contested. They were not contested at all by Mr. Beausejour McNamara or by the first respondents. To contest it now, at this late hour, offends the principles of the Privy Council case, in which I have in Oceana, which is at page 1154 of the bundle.
Yes.
Sorry, my lords.
Oceanus and Willard, yes.
Offends the principles laid down in Oceana Heights Limited against Appellants. To bring up a point at this time when it was never taken before is absolutely, I believe, on the reading of paragraphs 24 to 30.
24, did you say?
Yes, 24 to 30, my lords. 24
to 30?
Yes.
We'll read that to ourselves.
Yes, my lords. So there is that issue. And then there's the issue that because this point has been reiterated and, flogged both in the High Court and in the Court of Appeal, my lord, there was an opportunity to make that objection earlier. And the interesting issue is that the appellants stand on the ground that these were contracts. There were no attempt was made to avoid them, to appeal them, or to question them on the lines Mr. McNamara has only now decided to raise. That should have been raised way before in the courts below. And I think the Oceana case is instructive in that regard. And we're also saying that it is there should be a stop, and the principles of estoppels and the laws I'm sure that you're aware of, that in that regard, that it should therefore preclude the first respondent from defending this action in the way that they have had, when they had so much time to do so and at so many different levels to do so.
Thank you. Well, we'll leave you to get control of your mobile phone, Mr. Foster. That concludes your submission.
That concludes my submission.
Thank you very much. We will now retire for a short time to consider where we've got to. Well, thank you very much, Mr. Foster. We won't need to trouble you, Mr. St. Rose or Mr. McNamara. I should say Miss St. Rose or Mr. McNamara. The board will take time to consider what advice we will humbly tender to Her Majesty. Thank you.
Thank you, Lords.